Hello students, myself Dr. Gurdeep Kaur, Assistant Professor, School of Law, Maharaja Agrasen University. Today we will discuss the important concept under Transfer of Property Act 1882, that is transferable and non-transferable property rights. Before going to start this, we need to know what is the objective of Transfer of Property Act. So the Transfer of Property Act provides free movement or alienation and circulation of property for the benefit of society. It also provides definite, clear and uniform law for the transfer of immovable property. This act has modified and made changes in some of the rules which existed before its enactment. The changes were made so that the laws may be made suitable to the social economic conditions of India. Now, we discuss the general rule relating to transfer of property under the Act. The Act provides that property of any kind may be transferred, but there are certain kinds of properties which is not allowed under the law to be transferred. These properties are called non-transferable properties. For this, the person urging non-transferability must prove the existence of some law or custom which restrict the right of transfer. Therefore, transferability of property is the general rule, but the non-transferability is an exception. Now, one question has arisen, that is the meaning of property? The word property has a very wide meaning, includes properties of all description, that is movable, immovable, tangible and intangible property. According to William Goddard, in his classic work Elements of English Law, he said that there is perhaps nothing more difficult than to give a precise and consistent meaning of the word property. The property is a bundle of rights or interest. When a property is transferred, there may be transferred of all the rights in that property or some of it. In the case of Sunil Siddharth Bhai versus Commissioner of Income Tax, our Honorable Supreme Court observed in this case that transfer of property means passing of a right in the property from one person to another. In one case, there may be passing of entire bundle of rights, that is ownership from transferor to transferee, but in another case, there may be transfer of only some of such rights, that is partial interest. Now, we discuss the restrictions on the right of transfer of property by Property Act. Section 6 of the Act laid down the general rule that property of any kind may be transferred except as provided by this Act or by this section itself provides the restrictions on the transfer of certain properties. And in today's lecture, we will discuss these restrictions. Section 6, Clause 1. Provide the term spes successionis. It means the expectations of a succession. It is the chance of an heir apparent to succeed to an estate transferable. Here, spes means the hope or expectations. Under this, the following things made non-transferable. First is chance of an heir apparent succeeding to an estate. The apparent means an heir, but not a legal heir. Heir apparent is a person who would be heir in future if he survived the true owner. Let's take an example on this. In the case of father and son, son is apparently heir of his father and becomes legal heir after father's death. But if son transfers the property of father without his consent while father is alive, then transfer is void because son has no right in father's properties before his death. Another is chance of legacy. Here, legacy means expectations of getting certain property under a will. Such transfer by legacy is not valid transfer. It is well settled law that will operates only after the death of the testator, not on the date when it is written. Another thing is any other possibility of a like nature. Here it means any other possible interest of property which is an uncertain as the chance of an heir apparent or chance of relation of getting property under a will. The purpose behind it that any property which is merely a future uncertain interest should not made be transferable. Section 6 subclause B provides another restriction which is called mere right of re-entry. Here, right of re-entry means right to resume possession. When a person is entitled for a right of re-entry, basically in the case of lease or tenancy, and on breach of any condition, lessor or landlord can resume his possession. This right of re-entry is connected with the interest in a land. Mere right of re-entry not accompanied with any other interest is not transferable. So in the case of breach of any condition of lease or tenancy, the lessor or the true owner of house can terminate the agreement and resume the possession or transfer property to another. Next restriction is easement cannot be transferred apart from dominant heritage. Section 6 subclause C talks about easementary right. Easement is a right which exists for the beneficial enjoyment of a land or is exercised upon the land of another person. Here the land for whose beneficial enjoyment right exists is called dominant heritage, and the land upon which the right is exercised by the person is called as servient heritage. So easement is not a personal right, but it attaches to the dominant heritage land, and it cannot be separated and transferred without dominant heritage. The example of easementary rights are right to way, right to air, right to light, etc. And these rights will be useless without property. Another thing is restricted interest cannot be transferred. Under section 6 subclause D, an interest in the property may be restricted or reversed for enjoyment of the owner personally. Such interest cannot be transferred. For example, if a house is lent to a man for his personal use, he cannot transfer his right of enjoyment to another. This principle is based on the maxim res extra commercium, means things beyond any trade or transaction. This is based on the principle that what is intended to be enjoyed by a person as such cannot be transferred, as it is not intended to be enjoyed by any person other than the person in whose favor the interest is created. Most of the cases under these sections deals with attempted transfer of maintenance rights, service tenure rights, alienation of office by trustee or religious office like Muttawali of Waqt or Mahant of a month. And these rights and interests cannot be transferred. Section 6, subclause DD says the a right to future maintenance in whatsoever manner arising secure determined cannot be transferred. Because the right to maintenance is a personal right and can neither be transferred nor be attached in execution of a degree. Maintenance can be granted through personal contract or by order of the court. And this right is a non-transferable right. In the case of Tara Sundari versus Rodha Charan case, the Calcutta High Court said that the right of a person to receive for boarding, lodging, clothing, and other necessaries is known as right of maintenance. And right to receive maintenance is a personal right and for his her own benefit. And for this reason, it is not transferable. Section 6, subclause E says about a mere right to sue cannot be transferred. Section E of Section 6 provides that mere right to sue cannot be transferred. Here, sue means to make a legal claim or to take legal proceeding against any person. Right to sue for a certain sum of money is an actionable claim. Actionable claim means a claim for a certain amount of money and it can be transferred. But right to sue for unascertained or unidentified sum of money is not transferable. For example, A published defamatory statement against B. Under the law of tort, B has a right to claim damages from A. B thinks that he must sue A claiming rate 50,000 as damages. But instead of filing the suit himself, B transfer his right to C. This transfer of right to sue from B to C is invalid because this right is not non-transferable right. Section 6, subclause 5 says a public office or salary of public officer cannot be transferred. Under this, there is a provision on the transfer of public office and the salaries of public officers. A public office is held for qualities personae, that is, on personal qualification. It is a meritorious and competent person should be appointed to serve the people, and for that purpose, public office cannot be alienated or transferred as it will be against the public interest. For example, agreement to sell public office is provided in Section 23 of Indian Contract Act against the public policy, and it is held to be void. Along with this, salaries cannot be transferred. There are several reasons behind not allowing the salary of a public officer to be transferred. These reasons are follows. First, salary is given to a public officer for upholding the dignity of the office and for the performance of his duties. Salary is an incentive for his work, and salary is provided as to put the person in a state to perform his duties with dignity and to put him in personal comfort. For these reasons, it is against the public policy to transfer the salary of a public officer. Further, Section 6, Subclause G says pensions and stipends cannot be transferred. Under this clause, the stipends allowed to the military, naval, air forces, and civil pensioners of the government and political pensions cannot be transferred. In the case of Secretary of State versus Jayachand, Bombay High Court held that pensions cannot be transferred. Here, pension means a periodical allowance or stipend which is granted not in respect of any right of office but on account of past services. Under Section 60 of CPC, exempt a pension from attachment in execution of degree against the pension holder. Further, Section 6 Subclause Act says transfer opposed to nature of interest, etc., not to be transferred. Under this clause, there is prohibition in the transfer of certain properties under some situations. Section 6 Subclause Act provides that no transfer can be made in where transfer is opposed to the nature of interest. That is, the properties which is known as res communis, properties of the whole community of the world, is not transferred, and transfer where its object or consideration is unlawful. According to Section 23 of Indian Contract Act, the object or consideration is unlawful where it is forbidden by law. It is in such a nature that if permitted, it would defeat the provision of any law. If it is fraudulent, if it involves injury to a person or property to other, and it is immoral or opposed to public policy. So any property which is otherwise transferable becomes non-transferable when the object or the consideration of the transfer is unlawful, according to Section 23 of Indian Contract Act. Another case is transfer made to a disqualified transferee. According to Section 5 of Transfer Property Act, for a valid transfer, the transferee must be competent and legally qualified person. A legally disqualified transferee make transfer invalid. Section 6, Subclause I provides that untransferable right of occupancy. As a general rule, occupancy rights or the leasehold properties are transferable interest. But under this clause, there is an exception to this rule. Under this subclause, tenant cannot transfer an untraceable right of occupancy. Farmer of an estate cannot transfer the property if government revenue is due. And lessee cannot sublet if the property is under the management of court of wards. So students, these are the properties which are not transferable under the Transfer of Property Act. These are the exceptions of the general rule that all kind of properties can be transferred. Thank you.